Elvia, are we ready to go?
Yes, Mayor, we're ready.
Thank you very much. Good afternoon, and thank you for joining us on the special City Council meeting. I will now call the meeting to order at 5 p.m. For the audience tonight, I am the mayor and serve as the presiding officer for this afternoon's meeting. This afternoon's public meeting will be conducted utilizing Zoom video communications. This allows the city to continue to conduct essential business and comply with Public Health Administration recommendations to protect the public and city employees practicing social distancing and limiting exposure by not allowing in-person meetings. To ensure that the public will be able to participate, public comments can be submitted as live comments during our Zoom meeting and via email at publiccomments@cityofglendora.org. This special emergency meeting was called by Councilmember Thompson and myself due to numerous house parties throughout the city and most recent incident this last Saturday night that has been fostered and fueled by online rental services sites disrupting the expectation of safety and tranquility of our residential areas. To all of our residents, we heard you loud and clear, no pun intended, and the City Council acted expeditiously. I would very much like to thank our department directors and staff for moving so quickly and pulling together the necessary information, making this afternoon's special City Council meeting happen. I would also like to thank our city manager, Mr. Adam Raymond, for being the orchestra leader in the organization of this meeting, and special thanks to our Chief of Police, Mr. Matt Egan, and our City Attorney, Mr. Bill Winder, and his staff for their hard work in preparing all the legal documents and court filings. This afternoon's meeting will require a supermajority vote to pass the proposed action, meaning a minimum of 4 council members must vote in the affirmative. Madam Deputy Clerk, can you please do the roll call, please?
Yes, thank you, Mayor. At this time, I will take a roll call vote and request that each council member respond with present when their name is called. Councilmember Thompson.
Present.
Councilmember Boyer.
Here.
Councilmember Friedendahl.
Present.
Mayor Pro Tem Davis.
Present.
Mayor Alawas.
Present.
All council members are present, Mayor. Thank you.
Thank you. This brings us to our new business and our only business for this afternoon. Consider adopting an interim urgency ordinance approving a citywide 45-day moratorium prohibiting short-term vacation rentals and the advertisement of short-term vacation rentals in the city and declaring an urgency thereof. At this time, I'd like to invite our city attorney, Mr. Bill Winder, to present the staff report.
Thank you, Mr. Mayor, and members of the City Council and citizens and residents who are participating with us virtually by Zoom and on other platforms. Tonight's meeting was relatively hastily called to address an ongoing issue within the city. Events over this recent weekend were, to use the proverbial term, the straw that broke the camel's back. And that has prompted the City Council and city staff to direct us, working with law enforcement, to consider what options are available to the city and what remedies can be pursued in the short term, in the intermediate term, and in the long term to address what are perceived as the pernicious secondary impacts from short-term rentals, party houses in our community. And while we don't have jurisdiction over it, it clearly is a nationwide problem. In that regard, there are 2 additional partners of mine who are on the line today. And if there are questions that I am unable to satisfactorily answer or that I screw up, they're here to fix it for me. One of them you know well, Lana Lehman is the Assistant City Attorney for the City of Glendora, and she is present. And the City Prosecutor, whose name you've seen on other pleadings and other notices, Ross Trindell, is here to talk about a litigation matter that is about to go forward that I'll brief you on. So with that, let me start with the background. I don't think I need to recount for anyone the events of this last weekend, but suffice it to say, one of the residential properties smack dab in the middle of a residential community, turned into a near riot on Saturday with a large crowd not practicing social distancing, not engaging in face coverings, and violating a whole host of municipal laws, engaged in what can only be charitably characterized as an out of control party. So what can the city do about that? Well, we have worked with Chief Egan and his staff and our staff to look at 3 approaches to this problem. Approach number 1 is the administrative process, and that is we issue a series of administrative fines and citations, which we've detailed for you in the staff report. Administrative citations are after the fact remedies for violations of law. In this case, there were substantial law enforcement resources that had to be expended to address this party and to deal with its pernicious secondary impacts. And the cost of those services exceed $17,000. And in cooperation with the Chief of Police and his staff, we will be sending letters to both the property owners and the party promoter seeking reimbursement. So an administrative citation is a tool that is available to the city. The administrative citation process, however, is fairly cumbersome. You issue the citation and the fine. They're subject to appeals. Those appeals take time, and it has been my experience as a city attorney for some 40 years that they are routinely ignored even after the administrative citation and appeal process is concluded, and cities end up coming to our office to go collect these fines in any event. So for someone who's making thousands of dollars in hosting short-term rentals and turning them into large parties, administrative citations can very easily be viewed as just a cost of doing business. And I know I'm going to get cited, but I'm going to make more money from doing what I'm doing. And as a property owner, I'm going to make more money from allowing my property to be used than any administrative citation that could be issued. So administrative citation and enforcing the municipal code is certainly a tool that is available, and it is a tool that we will absolutely pursue in connection with this party. What about health order citations? We've talked at some length with representatives of the county council who are fully supportive of the city's concerns. They have their own practical problems. First of all, citations for health official orders are not even as substantial as are the administrative citations and fines that can be issued by the city. And if any of you are following the media, you will realize that Los Angeles County lost in court recently to shut down a church that was blatantly violating county health department orders and engaging in the very conduct that was engaged in connection with this party, only in connection with the worship service, which admittedly is somewhat different in kind and character. So administrative citations are certainly a tool and one that we will pursue. Second alternative, lawsuits, litigation. Ross has been actively involved in that. We have drafted a complaint. We will be filing and serving that complaint. It seeks to abate a public nuisance, and we hope to be in front of a judicial officer given the limitations of COVID-19 virtual appearances in court these days, in the Pomona branch of the Los Angeles County Superior Court Monday. And we hope that if we are successful in persuading a judicial officer that the events of this weekend constitutes a nuisance per se, we hope to obtain a temporary restraining order prohibiting the use of this property as a short-term rental until the issue of a preliminary and permanent injunction can be heard on the merits. Time will tell if the city prosecutor will be successful at that effort. And the other option that is available to you tonight is the option that is primarily discussed in this staff report, and that is the use of moratoria. I saw in at least one of your city council email comments some notion that adopting moratoria violates both the 14th Amendment and the First Amendment. And respectfully, that's simply not the case. Moratoria are statutorily created by the legislature in California and codified in Government Code 65658. What is the purpose of moratoria? If you have a particular problem, land use problem, specific use problem, or other activities that are going on in your city that need further study and analysis, a moratoria lets you preserve the status quo by prohibiting that activity for a short term. The initial term is 45 days, while you let your staff study the problem to determine if further legislative action by the full city council may be warranted to address and regulate the problem. And short-term rentals is an outstanding example of that. Cities are facing this problem all over Los Angeles County, all over the state, and I am certain all over the nation. And that is, what do you do with short-term rentals, primarily in residential neighborhoods? And there are several models out there that the city could consider. Some cities have absolute bans on short-term rentals / party houses. Other cities have adopted the Los Angeles model. The Los Angeles model regulates short-term rentals, but requires the property owner to be physically present during the short-term rental, thereby controlling the kinds of activities that go on and making certain that the renter of the property, the short-term renter of the property, is using it for the purpose for which it was intended. Other cities are, in addition to regulating short-term rentals themselves, are prohibiting the advertising of short-term rentals on the various platforms that are commercially available to advertise your property. Why is that tool potentially effective for the city? Because as a practical matter, most cities do code enforcement work on a reactive basis. Cities cannot afford the cost of staff to be out in the community looking for violations of law. So we rely on the residents of the community to alert us to these problems. By prohibiting advertising, you have limited one source of making your property commercially available for short-term rentals. And we have found that most of the reputable platforms that advertise short-term rentals will cooperate in preventing these kinds of party houses. Airbnb, for example, has issued at least one and probably several press releases making it very clear that its properties during the pendency of this pandemic will not be available for large parties. Now, Airbnb can't enforce that. The property owner who is absent from the property can enforce that. And in the case of this specific property over this weekend, the city prosecutor has learned that it was advertised for a small family gathering of 25. Unfortunately, the promoter of this property ended up inviting 300 to 400 of his close personal friends to this party, which included the selling of alcohol, and it was otherwise a commercial activity. So we have prepared for your consideration tonight a moratorium. This moratorium says that for the next 45 days, all short-term rentals of property in Glendora will be prohibited, and the advertising of properties for short-term rentals on various platforms will be prohibited. Some would say that this is a fairly draconian measure. I would say that's not the case at all. All we're really doing is preserving the status quo, which in our view is that there is nothing in our municipal code permitting short-term rentals, while we let our planners like Jeff Kugel and the assistant city attorney and their staffs look carefully at these issues, look at the various models out there for regulating short-term rentals, and come back to the council within the next 45 days with recommendations as to what to do on a going forward basis, which could conclude that we will simply allow this moratorium to expire according to its terms, because we really don't have a problem in this city. We just had this one horrendous problem this last weekend, but for the most part, the folks in Glendora who rent their homes out for short-term rentals do it very responsibly, and there's no need for regulation. Time will tell. There's an argument that you can read your code, since your code is a permissive code, to prohibit short-term rentals already. And we've looked at some of those provisions, and all I can say is that the cautious lawyer in me would not want to send my city prosecutor into court based on the current interpretations of our zoning code, which clearly were drafted long before the short-term rental industry and these various media platforms ever existed. We're no different than virtually every other city in Los Angeles County. Our zoning laws did not anticipate this kind of land use on a short-term basis. So we are recommending to you that you seriously consider adopting this short-term interim ordinance. We respectfully don't believe it to be draconian. We think it is responsible on your part, because we have now had one serious problem. And oh, by the way, the problem with this property is not just this weekend. Those of you who looked at the complaint prepared by the city prosecutor, which was a part of the staff report, will realize that problems with this home commenced as early as November 5, 2019, and have continued to this date, with last Saturday's event being the catastrophic event that it was. The last issue that I'd like to address briefly, Mr. Mayor, members of the council, is why didn't we just bust into that party with guns pointed and summarily shut the party down, kick everybody off the property, immediately arrest everybody and close the property down? And the simple answer to that is due process. We are not in that kind of business. That law enforcement, in the judgment of the city attorney's office, used the responsible course of action. They contacted the promoter before the event started and cautioned him that what he was proposing would be a violation of both county health orders and the municipal code. In the exercise of the First Amendment rights and the free association rights that some of the speakers by email today have touted, the promoter ignored our warnings. And once events began to spiral out of control, law enforcement responsibly, appropriately approached the promoter of the property, attempted to contact the property owners, and issued a series of citations and administrative citations, as well as other citations, which eventually closed the party down. Did it shut the party down instantaneously? No, it did not. But in my view, what law enforcement did was the only responsible thing they could do in a society that gives even lawbreakers fundamental rights to procedural and substantive due process. So that concludes my staff report. Lana, Ross, and I are here to answer questions. You have these options before you, two of which we are pursuing without council authorization. We don't feel like we need council authorization to do that. but we would appreciate you ratifying our actions, and then we invite you to give serious consideration to adopting this interim urgency ordinance. And with that, I'll be pleased to answer questions. Thank you, Mr. Mayor.
Thank you, Bill, for that summation. At this point, I'm going to open up public comment, invite members of the public to address the City Council. Each speaker will be limited to 3 minutes uninterrupted. Madam City Clerk or Deputy City Clerk, do we have any requests to speak and/or do we have any emails to be read?
Yes, thank you, Mayor. We did receive 4 emails prior to 4 p.m. today that were made part of the agenda packet and are available on the web for the meeting. In addition to that, after 4 p.m., we received additional public comments that I will read out loud.
Before you read that, just to get everyone prepared, if anyone wishes to speak during Zoom, please raise your hand in the Zoom room, please, so we can queue everyone up. Thank you. Go ahead, Elvia.
Thank you, Mayor. The first public comment is from Matt Russell, and I will put on the 3 minutes. Mr. Mayor and council members, a fundamental mistake of government at all levels is using isolated headline generating incidents as justification for making sweeping changes in policy and law. While I strongly support the formal legal action taken by the City of Glendora as plaintiff against these individual property owners as described in the filed legal complaint, I strongly oppose the enactment of any sweeping urgency ordinance against private property rentals of legally owned private property. This amounts to further infringement on our First and 14th Amendment rights which have already been gutted by state, county, and cities' actions in response to COVID-19. This proposed ordinance even piles onto this as 8 out of its 14 total findings. See Section 3 City Council findings, directly or indirectly cite COVID as justification for imposing this emergency action. This is neither right or justified. Consideration for any such emergency action needs to be based on legitimate concerns related to the existing public nuisance, noise, traffic, parking, city municipal codes. People have a fundamental right to engage in lawful commerce involving their private property and to advertise such, to speak and otherwise make known to others about such opportunities. Our proposed emergency ordinance would make it a misdemeanor to make known or communicate in any way, even to speak of such opportunity in person to another, per interim urgency ordinance section 4 moratorium subsection B. This is wrong and in my opinion illegal, as it clearly violates both First and 14th Amendments. The city attorney correctly cites existing Glendora Municipal Code in its formal legal complaint for remedy of damages from the specific property owners involved in this recent specific incident. The current Glendora Municipal codes are sufficient for the city and the police department to deal with these kinds of incidents. I strongly oppose any imposition of a sweeping unconstitutional ordinance banning private property rentals in the city of Glendora.
Looks like we have 4 hands raised currently.
Got one more that I'm going to be reading. Okay, here we go. So this next one is from Linda Herman. Mayor and council, thank you for stepping up and addressing the party house problem we are experiencing in Glendora. I live about 2 to 3 blocks from this house. The videos I have seen of the party on A22 were frightening. The blatant disregard of local Glendora laws and health department regulations in this age of COVID was appalling. These parties put the citizens of Glendora at risk, not only because of COVID, but of the presumed alcohol consumption and the problems that accompany that behavior. These parties are a drain on Glendora's budget for the extra costs that occur, such as extra policing and cleanup of area in the aftermath. I implore you to pass this ordinance tonight to preserve and protect this neighborhood, and more importantly, all of Glendora before a tragic event occurs at any future party. Thank you for your consideration of this pressing problem, Linda Herman. We've got one more that has come in from Cynthia Natalie Carrasco. I object to any short-term rentals less than 6 months in length. Our city does not need extra money. A few houses bring in revenue attached to these VRBOs, Airbnbs, and other short-term offerings online. It is absurd to use homes in neighborhoods for purposes such as a hotel. We aren't a beachside community or even close to a major international airport to justify anyone staying a night in Glendora. We know why people come, and it's to disrupt our way of life. The greed of homeowners who rented out the Sierra Madre home this past weekend to partygoers from out of town is unacceptable. For me, for more than 1 year, I've seen trash, police activity, and undesirables make their way near my neighborhood. Hotels are actively operating in our city. Let's leave the short-term tenants to those operators who have more protections in zoning and rights. The neighboring areas residents should not just have to grin and bear it. This isn't the Glendora I call home. On Sunday, Michael Alawa said, regardless this issue, we don't want to take a sledgehammer to an ant. No, sir, I don't want reduction in home values. People living in fear, strangers baiting our police officers, people moving away so they avoid your short-term rental properties that you want to eagerly issue permits for to make money. That's selling out the pride of the foothills. No, Mr. Alawas, no. Ban these outfits that profit off our city. End short-term rentals now. Thank you. We have received no others via email, and we do have some hands raised. We're going to start with Claire F. Claire.
Thank you so much. I really appreciate you taking my my hand raise. Dr. Claire Federick, I'm a professor at APU and kind of a nerdy researcher. So I just wanted to ask in this process, as we're examining what the next step should be, and this might be a question for Mr. Winder. I'm sorry, I haven't met you personally yet. But is there going to be some kind of canvas or research done about how many short-term rentals we have here in Glendora, what percentage of them have problems, or if a more sweeping measure like this is required? Is that sort of the purpose of that, to sort of gather more information? As I keep hearing on Nextdoor that there are problems that are elsewhere, but sometimes people feel like because they're below foothill, they're not getting the attention that this house got. So just want to bring that up to the council. I'm not sure if that's actually how people feel, but I think we should also really find out, how many are there? How many of them are serious problems? Are they all serious problems or just a few? But I think that's a really important piece of this, just so we don't punish people who are actually renting their houses out responsibly if they are, and not destroying our community. Thank you so much for hearing me.
Thank you, Claire.
Bill, if you want, I can answer that.
Wanda, can we wait until the end here?
Yep.
Thank you.
Okay, the next person up is Lee Blocks. Lee?
Yes, can you hear me?
Yes, you've got 3 minutes. Thank you.
Yes, I've been tremendously affected by this. There's been a number of things that have put my family and our safety and just been truly disrupted, from car speeding, doing burnouts at late hours, trash from Sierra Madre. We have found condoms. There's vomit, definitely underage drinking and drugs. We can smell all the drugs, honking during late hours past midnight, pedestrian disregarding any sort of street laws, just parading through the street, blocking driveways, double parking, loud car engine revving at late night, car music blasting through loudspeakers, trespassing private property, as I experienced this last Saturday night, not only for my house, but other neighbors, overcrowded with fire hazard violations, not only this last Saturday, but also many other weekends and sometimes during the week for the past year, disrupting the peace, fireworks landing on my roof and trees, fights and violence that neighbors have experienced in the front street, hundreds of strangers disrespecting the community and the neighbors when they park and when they come out of their cars, in fear of safety of our homes, our wife and our kids, because we cannot even go outside due to the level of hostility that sometimes is presented outside. And in the last few weeks, we have seen violence and shooting and deaths in other mansion parties, which have really put our safety at risk. And this is not the only house in Glendora that we have heard of. There's another party house on 1351 Lawford that we have heard similar comments about this. And we are just up to sick and tired of this. Has to stop, and we got to find a solution. So perhaps the ones that are responsible renting to a single family to do what Airbnb was probably meant to be, but this sort of situation has to come to an end. Thank you for listening, and I look forward to fair solutions. Thank you so much.
Thank you, Mr. Blocks.
The next person we have up is Andrew Mendez. Andrew, are you there?
I'm here. Thank you so much, Elvia. I really appreciate it. Mayor, members of the City Council, my name is Andrew Mendez. I'm a City Council member for the City of Azusa. I'd like to first say thank you for taking quick action for this matter. I want to be clear that I'm here not necessarily as a Azusa City Council member, but more as a real estate professional. As a resident of the City of Azusa, I was appalled when I saw the incidents that took place over the weekend. Particularly over the being dangerous, the fast cars, the loud music, people walking along Sierra Madre. That was disappointing to see, particularly over the obvious negligence for taking this pandemic serious. It was evident that social distancing was not a consideration during this party, and that's disappointing. And I certainly agree. I forget who made the comment, but this is certainly the straw that broke the camel's back. As you can imagine, here in Azusa, of course, we do have party houses, not the same situation per se, but we do have situations. So I'd like to support approach number one of course, the administration fees, and approach number two of a lawsuit and or litigation specifically against these individuals. I would like to add one comment though. That there was a comment made in regards to should we rent out only to single families or whatever it be. That there are of course fair housing requirements for renting properties out that of course need to be taken into consideration. Now, in an effort to not punish owners of other Airbnbs or similar websites who are run in accordance with laws, I am not in favor of a blanket or more specifically a permanent ban on Airbnbs and similar websites. We cannot and we should not allow a small pocket of individuals to dictate what the rest of the property owners can do. I do believe that something as drastic as allowing who can rent their private properties out in accordance with the law, when, how, and to who should involve a formal public hearing. Members of the City Council, Mayor, thank you guys so much. Appreciate it.
Thank you, Mr. Mendez.
Next one up is John Caddis. John, are you there?
Yes, I'm here. Thank you, Mr. Mayor. And yes, thank you, Mr. Mayor and City Council. I wanted to endorse the support for all three of the items that are here today, but I want to caution, as Claire did and as the first written comment did, about punishing all homeowners versus the ones that are causing the problems. With regard to this individual, it's been reported that he was and is a criminal, has been arrested many times, is a sex offender. And so while we rationally believe that if we set laws, people will respect them, by definition, individuals like this have already stepped over several boundaries. So there's no reason to think that a situation like this in the future would not happen again when faced with the right circumstances and the right individual. So while banning all homeowners might seem, or all rentals might seem to be appropriate, by definition, a criminal is going to ignore that. And I think most homeowners are responsible, this case aside. So again, I just want to caution against implementing something throughout the city, because whether it's people that may want to have a wedding, other situations where there might be a lot of people at a particular place for maybe a day or two. The homes in our city are somewhat larger. The acreage here is somewhat larger than other cities. So how we use our properties may be a little bit different as well. Thank you very much.
Thank you, Mr. Katis.
Okay, we've got one more.
Two more.
Two more. The persons, are you there? You've got 3 minutes.
Yes, thank you, Mayor, City Council. Many of you are hearing about the subject property for the first time due to the so-called mansion party on August 22. Most of you are appalled at what took place. Some of you have known it for a while as the Goddard Party House. Well, living directly across the street from this property, I've been hearing this property for nearly a year. You see, my family and I have been dealing with this property's parties, noise, litter, vehicle violations, and disrespecting renters for about a year. Many of you don't know that open house parties are a regular occurrence there. From crowds to cars racing to people yelling, sometimes at us, to car doors slamming all night, to trash, alcohol bottles, and even discarded condoms in the street. I, my wife, 20-year-old son, and 15-year-old daughter have seen and heard it all. In my 53 years, 51 at this residence, I've never had any interest in firearms, but having a front row view of the goings on at this, and a front row view of the goings on and threatening activity that often occurs at the mansion, I was compelled to purchase a home defense firearm back in March of this year. I'm not against guns by any means. I just never had any interest in them and certainly no desire to own one. I would be willing to bet all that I have on the fact that if the mayor or any of the city council lived in my house for the past 10 months, the hammer would have come down a long time ago. My fear is that this will all blow over, or the city will use COVID as a temporary excuse. I fear that the noisy metal gates of the mansion will soon open back up to the disrespecting tenants, and the whole cycle of complaints and we're looking into it cycle will continue. We've had enough.
We've had enough. It's ridiculous. It really is. If you guys were us, you would have had enough too.
And I know there's a few people who rent. Well, in a democracy, sometimes you have to make sacrifices. The very few people that rent their properties versus the general public, the general public should prevail.
Thank you.
Thank you, the persons.
3 more, Mayor.
Okay.
We have next one up, Vacation Aid LLC. Are you there? Vacation Aid LLC. Next one up. Nope. Okay, let's move on.
Hello, can you hear me?
Are you there?
Yes, I figured it out. Can you hear me?
Got 3 minutes.
Yes, go ahead.
Okay. Thank you, Council. City Council, thank you for listening to me. I did send an email out earlier, but I guess it did not go through. I sent it late last night. I have a company there. We've learned how to manage the short-term rentals. It used to be called corporate housing, but because of technology and website, platforms like Airbnb, Booking.com, VRBO has made it easy for the common person to do it, similar to Uber and Lyft and things like that. I manage properties throughout all of Southern California. We hire about 7 people that do landscaping, interior design, marketing, cleaning the homes, and putting this moratorium on it would devastate our company, and you put about 7 people out of business. I understand there are issues. Airbnb has already moved forward in addressing these house issues, where they're not allowing any party houses on their platform anymore. they're actually suing guests and suing hosts now for that are violating the agreements. And I believe the city of Covina can do or Glendora, excuse me, can do the exact same thing. I'm willing to work with you guys. I've been doing it for 4 years, but to do this broad brush and kick everybody off, put the moratorium on for everybody, that's wrong. We're seeing that way too much right now in this nation, where we see one cop do something wrong and all the cops are being labeled as a racist. What the council here is trying to do is somewhat similar to that, where one bad person is not following the directions of the house rules, and now you're blaming everybody across the board for it, and that's wrong. That should stop. It's not constitutional. We should be fair. We should be rational. And Glendora is the entrepreneur type of place where people go and thrive. People love the city. Most of my guests are there because they're going to the City of Hope. They're cancer patients. They have family reunions in the area where they want to visit family. They're graduating APU, Laverne, Claremont, so they stay at my place while they're working on their doctor's degree. And they bring their entire family along with them because they don't want to be away from family for too long. So by approving this, you would, first of all, paint everybody with the same stroke. So please vote no on that. No for 7 of my employees I would have to lay off right away if this goes through. And during a time where COVID is already taking so much and the city and the county, state still refuses to open up for whatever reason, it's too much. And don't, I just ask that you be rational about this, be fair about this, and don't make emotional decisions. Let's look at the facts. I think one of the APU professors that looked at it, how many of us actually do short-term rentals and how many are actually problems? And I bet you it's a small percentage, 1 out of 100, I bet. Because all I hear is one house being the problem area. And yeah, shut those places down. So
Thank you, Mr.
yeah.
Carmona.
Okay, sir, I appreciate it.
Thank you.
Thank you. Ryan Sineth, are you there?
Yes, I am here. Do you hear me?
Yes, you've got 3 minutes. Thank you, Ryan.
Perfect. Thank you. Well, respectfully, to the gentleman before me, whether or not it's 1% or 100%, it's still unacceptable. We can try working with it, but we're in the middle of a pandemic. People shouldn't be going out vacation anyways. It's be staying home. And whether, like I said, it's unacceptable to our communities. If it, whether here or anywhere else, it's not right. So that's why I fully support this motion. Thank you.
Thank you, Ryan.
The name is iPhone. Is that person on?
Hello, sorry about that. I'm not sure how to change that from iPhone. This is Megan Aguilar. And I just wanted to say thank you for moving quickly on this. I know this is a problem though that they've been dealing with since November. I applaud the fact that you're willing to take 45 days and dig deeper into this. I hope tonight that this motion does go forward and you do take those 45 days. I consider this a serious safety risk on many levels, not only COVID, but on the things that happen as a result of these parties in cities. And I speak from firsthand knowledge. I do come from a law enforcement background and I've seen what can happen. I live in the city of Glendora and I thank the Glendora Police Department. I know extreme measures were gone to on Saturday. And I understand why what happened. And I hope that city council and the mayor can take these 45 days to put in place tools that can be used to effectively control what is happening at these short-term rentals. Thank you very much.
Thank you, Ms. Aguilar. Is there any other folks that wish to speak?
No others, Mayor.
Thank you, Elvia. Then I will close the public comment, bring it back to council. Since myself and Council Member Thompson brought this to the council as a special item, I'm going to go first and then I will let Mendel go second. So with that, I'd like to see if our city manager can answer the 2 questions that came from our public comments. One was from Claire about how many short-term rentals there are in Glendora. Adam, would you care to answer that?
Good evening, everyone, and the mayor also too. The health officer, I believe, is on the call as well for the
correct.
So Just if I could take a moment just to provide some perspective, we are talking largely about an incident at one house as the city attorney sort of moved into it, and that one house combines a nuisance property from partying. It also happens to be a short-term rental and a blatant sort of an absent look at the COVID issue that we had. So there's about 51 short-term rentals that we can help identify. There are companies out there that help notify, such as HDL, how many short-term rentals there are. We inquired through them today. Our total came out to 51. There are 2 homes in town that do create most of our calls for service for noise and parties of late. Both of those are short-term rentals. However, we have had issues with owner-occupied homes in our town before as well with nuisance. So part 2 of the staff report, item 2, the first is the 45-day moratorium. The second recommendation before council is for staff to come back and study the issue, in which we would study, both of what are the options out there for short-term rentals. More beach communities have suffered or have had to enter into sort of moratoria or highly regulated short-term rentals before. As a place where many people come and go for short periods of time. As time has gone on, and facilities such as cities such as Glendora have larger estates that can be used for other events, those cities have had to deal with short-term rentals as well. But we would take that time to sort of background and go over the options before and make some proposed changes, including addressing nuisance properties as well, which can be owner-occupied, long-term rentals, short-term rentals, but that is a conversation that is both concurrent and separate at the same time.
Mr. Winder? Yes, sir.
I'd like the Assistant City Attorney, Ms. Lehman, who is the principal drafter of this ordinance, to respond to some of the concerns, in particular the professor's question. Lana?
Yes, hi, can you hear me?
Yes, Lana, go ahead.
Okay, very good. First, I have actually a couple of points to make. First of all, with respect to our good actors, our businesses or other bread and breakfast establishments that actually have a commercial permit or have received a business license, they are exempt from this. So there should be no worry about, hotel or motel or bread and breakfast shutdowns in terms of this moratorium. Secondly, I think there's a lot of focus about this being just this one house, but in these COVID-19 times, we need to be concerned about mass gatherings anywhere, whether it's this house, another house, a multi-family complex that is rented out. That's why we have the 45-day moratorium proposal. And that actually brings me to the final point, which I think is probably the most important one, which is that the moratorium is a 45-day study period. It is a study period in which we will look at and evaluate precisely what we have to do, what we need to do, and what the impacts are, and develop regulations as needed, or extend that period of time as needed to develop proper regulations to deal with this somewhat new virtual situation.
Thank you, Lana. The other question that we had from Mr. John Cadis is short-term events. Adam, can you answer that? I believe we have in place applications or apparatus for application for short-term events.
So we do. We have a special events permit that's followed. So for anyone that would violate the special events permit, again, it's an after the fact approach too. So, but we do have a specific process when there's going to be lots of people impacting streets and neighbors. It requires signage or sign off on street usage, the surrounding neighborhoods notified, and certain hours and operations, sort of the restrictions around those are placed too. So it is a official permit process, included our municipal code and adopted through a city policy. So that is readily available.
Thank you, Adam. On Sunday morning last, my inbox blew up over angry residents, and rightly so. And I apologize for your disruption, fear, and anger over the party house disaster on Sierra Madre. After answering emails, I called Brian Chesky, the CEO of Airbnb, and spoke with his handler. Gave him 12 hours to reply, then he didn't. And when it didn't happen, Councilmember Thompson and seconded my request to have this special meeting. Then also our city manager, Mr. Raymond, set up a quick Zoom meeting with all the residents at 3 o'clock on Sunday for a 5 o'clock meeting. We had 112 folks that joined us. It was very well attended. And there were several questions that came up. And I'm going to pick this one first about the health department and their involvement. So we have on the line, we're very lucky and very lucky to have Dr. Davis. He's the health administrator for Los Angeles County. He's with us tonight to talk about certain items. We gave him some list of questions that we had. Dr. Davis, are you with us? I saw you earlier.
Yeah, you need to unmute yourself. Dr. Davis?
Can you hear me now?
There we go.
Okay.
Yes.
Yeah. Sorry about that. I'm sorry I'm not on video. I'm technically challenged. They're working on my computer.
That's all right. You're with us and we're grateful for it.
Thank you.
So I had sent you a list of questions. What does the County Health Department of Public Health do when notified of large gatherings when violations of the county health order are reported? First question.
Yeah, so it depends on, what it is. For this particular instance, like a house party, we often don't hear about it until after the fact. Typically, you all at the city level, whether it's the police department or others, will hear about it and be able to respond in a quicker fashion than we do. Like I said, we may not hear about it until the next day. We have, I believe it's for this address, sometimes when we have repeated violations that we are aware of, we will send a notice of violation or a cease and desist letter, which basically notifies that the violations of the health officer order have been observed, and if repeated, we'll note that as well, and laying out the grounds for why it's not permitted at this time, in addition to what might be some of the penalties should the activity continue.
And the second question is, how does the county public health work with local law enforcement, county council, and the DA's office to work with egregious offenses of county health order?
Yeah, again, I think it depends on the situation. And actually, we just had a call with, Police Chiefs Association, county sheriff, as well as the city police departments. And we'll talk through that a little bit more. But in general, as we have repeated violations, if we're out and we need to keep the peace, we will call law enforcement to help do that. In some instances, we may request, because we don't have the authority to do it, that law enforcement write a misdemeanor citation to begin that process. And where need be, we will engage with the city attorney, or if it's in a county unincorporated area, we'll engage with the district attorney to move forward on any other legal aspects or legal actions that need to be taken in order to get adherence to the requirements that are set forth.
Thank you for that. I'm going to, since you're on the line with us, I'm going to open up to the rest of the council to ask you questions. Mendel, do you have any questions? Dr.
No,
Davis?
I don't. No.
Gary?
Actually, a couple. The first question I have is, if there's a report from local law enforcement, exactly what can be done to address the issue immediately, as opposed to writing citations that, let's face it, the citations are just going to be ignored. Is there a process anywhere within the law that people can be removed if they're in a situation like this?
Well, I think that's partially a question for your law enforcement. In code, as there are active health officer orders and there are no gatherings, so that party is a violation of the order. law enforcement does have the ability to enforce those orders. The question of what means they use, whether or not they physically break up the party or they, physically, remove someone from the party, I think those questions are really for law enforcement to answer. But I will say, just in general, again, the party was a violation of that order, and then the process for enforcing that, can go a few different ways. But sometimes, and I've seen where law enforcement has used different measures in order to do that. But I think part of that question is going to be for law enforcement. We aren't peace officers, so we can't arrest anyone in that way. So our mechanisms are definitely probably much slower than what law enforcement might be able to do.
Understood. So, I mean, the next question, I guess, would be, there is no enforcement level or enforcement agency at the county level that has the ability to do this. With the health department, if you go into a restaurant and there's issues and the restaurant's not clean, there are things that can be done. But I guess what at the county level can be done as opposed to just writing citations?
Well, so this is the difference between permitted businesses and unpermitted. And so a house party is unpermitted. They don't require us to have a permit to operate, unlike a restaurant, which needs that in order to operate. So for us, it is going to be, fines, and hopefully, if you need to, misdemeanor citations. The fines can go for each violation each day that happens. But again, this is very different from what you would expect from what law enforcement can do in general with other violations of code or crime.
Okay.
And our environmental health department is the one that's actually receiving all the complaints and does follow up on them in terms of, either assessing or looking at or, writing fines or recommending issuing of orders to close or compliance.
So Councilmember Boyer, I can add to that. I've had conversations with an attorney in the county counsel's office who is responsible for litigating some of these health order violations. So the county council can litigate these in civil court just like the city attorney's office can.
Exactly.
Okay, so I mean, just to follow up, and I'm sort of beating a dead horse here, let's go back to the restaurant scenario. You've got a restaurant that has health violations. We take their license away. They don't shut down. They keep serving hamburgers. I'm stopping there every day and eating a hamburger at an unlicensed restaurant. What could possibly be done? How can that be enforced at what level? I know we can take civil action. I know we can write citations. Is there a level at which somebody can physically go in, put somebody in handcuffs and take them out of there and lock the front doors?
Yeah, but that goes through the legal process, and that's where the misdemeanor citation has to start to ratchet it up. Again, for a restaurant, the license can be suspended or revoked, meaning that they're essentially operating illegal. And if they want to continue to do that, then it starts to ratchet up in terms of the legal process. But it's not as quick as you may want to see, and that's just the way the codes are in relationship to these types of violations.
Councilmember Boyer, can I add to that?
Sure, please.
The situation is a lot like the failure to pay rent. The law prohibits a landlord from summarily evicting a tenant for failure to pay rent. There is a legal process that you have to go through to evict the tenant. Ultimately, if the tenant refuses to leave, the marshals come in and haul him off. Same thing would happen in the context of the violation of health orders or violations of the municipal code. Self-help, unfortunately, is not a remedy.
Yeah, no, I appreciate that. And one of the things that's really frustrating right now for all of us is the fact that there is a mentality with a certain level of our population that just thumbs their nose at the law until we get to that level of being able to physically do something. And I think it's important for us to try to figure out if we're going down the right path or if there needs to be some adjustments into how we can enforce the laws that we have in books. So anyway, I appreciate the answers. That's all I had, Michael. Thank you.
Thank you, Gary.
Yeah, if I can make one additional comment, I mean, I do think that I hear what I view as a little bit of frustration in terms of the process. we are going through that as well. I do think that, in all of this, we're probably not going to enforce our way out of it, but there are different things that can be done. There are certain authorities and powers that each of us has at different levels. And I think we just have to figure out what's that right mix and where each of us comes into play. But it does have to be a partnership around this enforcement. And we've seen some other, measures taken at the city level as well in other cities. So we're happy to engage in that conversation, and we will moving forward.
Thank you.
Thank you. David, do you have any questions of Dr. Davis?
No, just thank you, Dr. Davis, for your time and for contributing to this process.
Thank you, David. Mayor Pro Tem Davis to Dr. Davis.
Yes, thank you, Dr. Davis, for all that you and everybody else at Public Health has been doing. And to follow up on what Mr. Boyer said, I'm sorry that so many people thumb their nose at science and the guidelines that you've been trying to provide us to keep us healthy. So thank you. And hopefully in the city of Glendora, we could do some things to get that message across. So thank you.
Dr. Davis, thank you so very much for joining us. I know you're a busy man, so we'll go ahead and let you sign off if you choose to do so, and we'll get on with our meeting at hand. So thank you again for joining us. So one of the other questions that we had that came from the affected residents was why can't the fire department come in or the fire marshal come in and close it down for overcrowding? And so I'll put that off to Adam and or Bill, if either one of you would like to answer that question.
So I'll actually ask Chief Egan to come on and sort of walk through that process.
All right.
I would just mention that during this time also 2 of the 3 largest fires in the state of California's history are going on, plus the fire department here does provide sort of the medical assistance. So, and if the chief's on, he can walk through the occupancy and other related issues that we talked about.
Chief?
Yes, thank you. Well, for starters, the fire department question is a very good question. Typically, that's not a tool that's used. Fire department occupancy levels for licensed locations have set a number of occupancy standards, and that's based on fire department their critical entry, exit points, safety points, safety corridors, door closures, and the like. And so for most commercial structures, restaurants, and other establishments, there is a maximum occupancy that is declared. Private residences are a different story. They typically do not carry those. There are typical building standards, which Jeff or Allison, fellow directors in building and planning, that can talk to you about typical heights of windows for escape routes, the number of doors, access points, what those door lock and mechanisms are, but that's not something that is closely regulated by the fire department for an inspection of this type. So on that night, obviously we had a large amount of people there. Estimation was 300 plus. Obviously it's a home that's registered as a single family home, and I doubt 300 extended family members arrived at that house to celebrate a function. And so, yes, there was far too many people at that house. I think that's an obvious assumption. How the fire department becomes involved on a typical basis is in advance. So if it's a planned event, meaning that it's a city planned event or even something at the community college level or school district, they'll come out and they'll provide an assessment to escape routes, to fire department egress and points and rescue points, and then sign off on that special permit. Since this event was not permitted, it was not permitted by the city, and we did not issue a permit for this event. The fire department wasn't involved to basically say, you can have this event, but you can limit it to only a certain amount of people. And you have to provide this access point and that access point for rescues. So they weren't called in. During the night when the actual event was happening, the best course of action that was decided during that night was to handle the party promoter as the point of contact. Instead of causing a larger problem by entering that property with a lot of different resources, making orders and demands for them to leave, having contentious interactions between partygoers and police officers. It was a recipe for, I don't want to say disaster, but the potential was there for a lot of not great outcome, for lack of a better term. The party was supposed to go on until 2 o'clock in the morning, and by way of issuing those administrative citations, the party host gave up at midnight, just after midnight, when we were issuing him citation number 3. I think the fines, he realized, had reached a level that he no longer wanted to play with, and so he called it quits. Now, unfortunately, it took 90 minutes for that party, or a little greater than 90 minutes, for all the party guests to leave the area and for the neighborhood to be quiet. But in the end result, there were no uses of force. There were no complaints received. We had no fights. There was no violence. There was obviously loud noise. It was a nuisance. There's trash left behind. The party guests were unruly. There was driving issues. All of the things, all of the version of events that all of the residents cited were absolutely accurate, and it was unacceptable. So I got a little off topic. Apologize for that. But back to fire department. They were not used that night, and it was a strategy to deal with the party owner solely and hit him with administrative fines. Fire department can't issue any fines, but a fire captain or an official from the fire department could say that this is an unsafe event and it needs to close, but that would be again directed at the host, and that host would have to comply with the LA County Fire Code, which would result in LA County Fire Code citations and county council to prosecute. So we thought at that time the best course of action was to hit him with the administrative fines and continue to stack him up until he gave up and called it quits.
Thank you, Matt, for that. Our Glendora Police Department did an amazing job in an untenable situation. So and you can stay there. When I have about 9 quick questions, and I'd like to hopefully we can get through them pretty quick. When the police department goes out to the public disturbance call, do they gauge the noise levels as prescribed in our municipal code 9.44.04?
Yes. However, it's based upon we don't use a decibel meter for any kind of noise or ambient noise regulation. We use basic common sense. So a police officer will pull up, they'll pull up directly in front or near the target location. They'll get out of their car, they'll turn their car off, they'll stand, they'll listen. And if they hear noise, then it's obvious, then it's violating the code, especially when they're one house away. Then that house can be subject to that administrative fine.
Thank you for that, Matt. My next question is for Jeff Kugel. Now, are short-term rentals, do they fall within a definition of a hotel per our definitions in our municipal code 21.0120? I know we touched on this just a little bit with some of the dissertation from Mr. Winder, but could you give us more detail on that, please?
So the Glendora Municipal Code does not specifically address short-term rentals as they're really currently known in the market, where in the last 15 years or so, you've seen short-term rentals enter into the single-family areas where investors or homeowners rent those units. You are correct that hotels are defined in the municipal code, and hotels are permitted in a variety of zones in the city, primarily commercial zones in the city. The interpretation of hotels has not been extended to, in the way it's been administered, to individuals, homeowners, investors who may rent single-family homes. Single-family homes are rented on a regular basis. Hotels are further defined based on the use of the property for sleeping purposes. You're renting for a period less than 30 days to sleep overnight. And we did talk about what the current code says with the city attorney internally. In this case in particular, the issue was not really a hotel activity at this house. What they were doing is they were renting out the single family home for a party. And there have been instances where people who own homes in the city have rented their single family homes out for different types of commercial uses. In this case, it appeared that they were actually charging to attend a party, so it was almost a nightclub. But getting back to whether or not a short-term rental is a hotel, because the definition of that relative to a short-term rental is a little bit ambiguous. In discussing it with the city attorney, we didn't feel like it's explicit enough to define the short-term rental of a single-family home as a hotel, hence the recommendation for a moratorium.
So in practice, though, a short-term rental is acting like a hotel, and there's some ambiguity within our ordinance.
Correct.
I would agree with that too. Yeah.
I would say there are some similarities. You can use a short-term rental to sleep, but you can use a short-term rental to do a variety of things that don't include sleeping. So clearly the code was written at a time when short-term rentals and these platforms didn't exist.
Mm-hmm.
I would not want to march into court and rely on that provision of your code as already prohibiting short-term rentals.
Thank you for that. This next one, I know we touched on it just a little bit, do we have city zoning laws regulating where hotels, motels, and inns can operate? We touched on it a little bit. Can you expand on that, Jeff?
Really beyond what I said, the answer to that question is yes. We do have, standards for hotels, motels, and places in the city where they can be located. And hotels, I think the interpretation of that is that they are a hotel, like it's on Route 66. It's not the use of a single family home as a hotel.
So which leads me to the next question. We have approximately 40 to 50 short-term rentals in our city that we can identify. Are they in these zones for hotels, motels, and inns that we know of?
I was not involved in researching the location, but assuming that all of these 40 to 50 single family homes are in residential zones, those are not zones where hotels are permitted. In single family zones throughout the city, which is the bulk of the city, those zoning districts are permitted for residential uses for where people live. Other than that, the only real other types of uses that are permitted in residential zones are schools and single family residential zones as opposed to multiple family zones, are schools and places of worship. So really, when you're looking at those single family zones, those three uses are the only things that are permitted in the code.
All right. Would you agree that short-term rentals by definition is a business?
I think, Mayor, this is Adam. I think the short-term rentals, because it's not defined in our code, it would be unfortunate for staff to give their personal opinion if a short-term rental is a business. I think we would expect, if it comes back as regulated, that would definitely be something that would be required as a business license to operate a short-term rental. But a lot of what we're talking about is ambiguous. And to clarify a little bit on Jeff's previous comment, with single family zones, there are multiple family zones in which hotels could be located, in which there could be then residential short-term rentals. And we don't have the specifics documented from any company as to the identification or location from all these places, because an Airbnb, it could be an entire home or it could be a room, or a similar site. So that's a little vague for staff to be answering that question.
Okay, well, that kind of takes out my next question, but I have a follow-on to my next question was, how many business licenses do we currently have on record for short-term rentals in the city?
It's not regulated, so therefore there would be no required license.
All right. So far, according to Municipal Code 5.08.130 states apartment houses, duplex, mobile homes, parks, trailer parks, industrial and commercial rentals shall pay a business license. You know, by definition, it kind of sounds like short-term rentals are commercial rental because they're trading in commerce. The language in the section could have a meaning as being exact or very specific. And I guess that's something that we have to kind of go through and clean up, it sounds like. Because there's some
That's
ambiguity.
exactly correct. I mean, I think not just a little, I think there's a lot of ambiguity. I mean, the whole entire industry evolved, you know, before the codes in the city of Glendora have changed. And so as recommendation 2 in the staff report states that staff would take this time if the moratorium was approved to go back and research and provide recommendations to the council to provide answers to all of the questions you had and then some.
So short-term rentals, it sounds like right now are unregulated by name and are not only disruptive to our residents' lives, but it is also an affront to our legal abiding businesses such as our motels and hotels and inns. And they're doing the right thing by paying their taxes, TOT taxes, that the city of Glendora currently is not getting from the short-term rentals. So I would imagine that's part of this analysis that staff is requesting us to look at in the 45 days.
Most cities that do an active short-term rental also require those short-term rentals to pay TOT. That's correct.
But we like your clever reading of the city codes, and we should make you an honorary city attorney. What rate we should bill your time out to the city council?
I've been accused of that before. Thank you very much.
I resemble that remark.
Yes, you do. So with that, Councilmember Thompson.
Mayor, thank you. And I want to say thank you to the council and to the staff for creating time for this very important exchange. It's been a bang bang sort of thing. I really became involved with this over a year ago, as often I will walk some of that area. And often I am stopped by neighbors that ask me about what they can do, what we can do. And I know that Adam, since he's been on board, I've had several exchanges with him about this. And Saturday night, I think Bill said it right. It was the straw that broke the camel's back. And I took it upon myself to take a ride up there around about 10 o'clock, and it was appalling. It was scary and frightening. I observed things that nobody should have to put up with. Threats and language and attitudes being displayed against police were just not right. And everything that our chief and Bill have said is absolutely spot on. And I think it's important for the public that may or may not know, and this has been said, but it's true. This has been going on at this house for several months, not to the degree that we saw, but certainly it erupted on Saturday night. I also went down to Vaughn's on Foothill and Grand, where the flyer had said that there was a shuttle, and in fact there was a school bus that was parked there. And Chief, I don't think that you had mentioned what you all did there, but could you just give a kind of a snippet as to how you all were able to circumvent some of what was going on there?
Absolutely. So obviously we got alerted that that was a shuttle point, that they were directing party guests to park there and that they'd be ferried up to the target or up to the house up on Sierra Madre. We flooded the area with police officers and contacted a lot of, quote, shuttle vehicles. Some were colorful in nature. One was a motorhome. Several were school buses from not Glendora Unified, but rather contract school bus companies. We started contacting those drivers and informing them that if they were going to carry passengers, they needed a Class B license and insurance to do so. Turns out none of them did, and so they took the smart route and turned away. There were some, though, that were lawfully licensed and did make some visits up there. By us curtailing a good majority of that, the unintended byproduct is that people descending on that area to go to the party ended up figuring out where the party was, which put them up into that neighborhood, which caused parking issues and a flood of activity up there. The good part about that unintended outcome was when the party actually ended and the party promoter called it quits and people started to leave, they didn't have to walk all the way to 400 West Foothill over to Vaughn's to go retrieve their cars, because by that time the shuttle buses were gone and the party had ended 2 hours before it was scheduled to end. So they walked in the neighborhood, found their cars, and left. So it actually ended in a somewhat better fashion than it probably could have.
Thank you, Chief. And so my observance of what was going on was not only at the actual or outside the mansion or the party itself, but further south, as you know, to where I observed that. And so part of why I was compelled to support having the exchange that we're having is that there's a lot of risk that the city could incur, that people could incur, that could happen with outcomes that may not be bad by allowing this kind of action to occur. After that, and through a series of texts and conference calls, as Bill has pointed out and Mayor said, there was a Zoom call on Sunday at 5 o'clock where 112 folks dialed in. Not all of them spoke, but a lot of them did. And there was a high degree of concern for their safety, for what was going on. And I think that the inordinate amount of people on a Sunday night to Zoom in at that point really spoke to the need for the city, for the council, for staff to take a serious pause and look at all of this. As has been already said, there's another house south of here that has a lot of issues. And so my support for what we're doing is to not wipe the option for people to rent their homes out. I'm a free market guy, and I think that if there's a way to rent your house out or a room out, that is great. But I also think that the bigger point that we all need to think about is the safety of the citizens that live here, the quality of life. And I don't think there's anything wrong in setting aside up to 45 days to pause and take a deep breath and say, how can we better streamline so that rentals can occur, that people can do what most people are doing well, as I think has been said, that right laws are, passed to protect the people that are doing right, but to allow the city and the staff to enforce against those that choose not to do right. And we were confronted on Saturday with a gentleman who basically said, I'm going to do it. You can try and stop me, but I'm going to do it. And in fact, he did do it. And so I don't think there's anything wrong in pausing and looking at this. I am one that I hope that we don't have to take all of the 45 days. If we can figure this out and have something for September the 8th, and we can move on this, then that would be great. Okay, questions. Ross, you have been sitting there looking so good and everything. So I'll direct this to you since you're the lead guy on Monday. So could you help us to know a little bit about if you're able to see a judge? I'm assuming that that's who you're going to see. If he or she says, I do agree, it's a nuisance house, could you take us through the steps that would enlighten us as to how quickly that house could be tagged as such?
Yes, Councilmember Thompson. The hearing on Monday is going to be what's called an ex parte application for issuance of a temporary restraining order. And it also asks the judge to set what's called an order to show cause for the issuance of a preliminary injunction, which essentially extends the term of the temporary restraining order for the duration of the case until the court can make a determination on evidence that comes in through the various procedures. If the court agrees with our application and issues a temporary restraining order, that is a judicial order that the activities at the house will not be able to accommodate short-term rentals as it did before. Also, in our TRO request, we're asking that the promoter, Mr. Bell, not be allowed to advertise or engage in any of the promotional activities that were associated with this house anywhere else within the city. So effectively what that does is it holds the status quo of no additional rentals until the case is over, and until we achieve compliance with the Glendora Municipal Code, as well as the health orders, and as well as no advertising for additional parties. That is a judicial order that can be enforced via contempt proceedings, which can result in additional fines, as well as a possibility for jail time. The preliminary injunction, as I said, essentially extends the duration of the TRO through the case during the pendency of the case, with the same types of legal consequences that attach for a violation of that order.
Thank you. And if we lose that on Monday, which I hope that we wouldn't, can the city appeal that to a higher court and get an answer soon?
We would have the opportunity to take that up to a court of appeal, given the nature of the relief that's requested. Part of the basis for a TRO and a preliminary injunction is a showing of irreparable harm. I think in this case, given the circumstances with COVID-19, the fact that this can be categorized as a super spreader incident, I think that the irreparable harm is pretty clearly demonstrated. It would be, I think, a short order, we'd be able to take that up for review.
Okay. Ross, while your mic is live, so 45 days is what we're asking for to night. If this can be worked out in 25 days, is that good, or do we have to take the entire time?
In terms of the ordinance, I would defer that to Bill Weiner, the city attorney.
Okay.
In terms of how it is we go about addressing this case, it really depends on the level of cooperation we receive from Mr. Bell as well as the property owners.
Okay. Well, Bill,
since you guys have been taskmasters and have been beating us to get this job done on like 5 minutes notice, which of course we can do for a nominal fee for you.
Yes, we know.
Yeah, we think we can get something crafted. The problem is that there are lots of models out there that you could look at, and we want you to look at them all. And one of the models is everything's great except for this one crazy house. But until you look at them and until we assemble them, I sent I sent Adam a memo that we did for one of our other city clients that went through this same study process. The city of Rancho Palos Verdes looked at the various options and ultimately, although it doesn't sound like it's particularly popular here, ultimately adopted an absolute ban on short-term rentals. But we looked at the Los Angeles model, we looked at a number of other city models, and the council made a policy call. And you're going to be asked to do that. Can we do that with you in 45 days? We can do that with you in terms of gathering the options, because there are lots of regulations that are on the, that we can take off the shelf and share with you. Gathering your specific community data will probably take a little bit longer. But yeah, could we have something back to you in 45 days that you say yay, no, or maybe, or further study? I think the answer is yes, we can.
I actually, Bill, if I may break in.
Yeah.
Is that
Yes,
okay?
go ahead.
Yeah, so during the initial 45-day period for a moratorium, the council may hold a second noticed public hearing, and that will require a 4/5 vote and extend the moratorium for a number of months. As part of that meeting and extending the moratorium, the council must also review and approve a written report detailing the measures taken to alleviate the condition which led to the adoption of the first moratorium. So I think, again, this goes back to some of the public comments that we heard with respect to having a report and how we address it. I do think with respect to dealing with this short-term rental issue and adopting a new ordinance to address it, we may not be able to do that within 45 days. We can extend the moratorium as we continue, but you will come back with a report.
Okay. Well, I certainly don't, I'm not inclined to extend it because that's not what I want us to do. What I'd like us to do is, as I've said, pause and gather as much of the data, facts as we can, and bring our code and laws current. And so that as these homes continue to expand, and hopefully we won't have more of these type of homes, but there is a good chance that it will, that we have the ability, like I said, to allow the people that abide by our laws to live within those, but to also make sure that people who choose not to have a price to pay. So let me go back to the 50 or so folks that have a short-term rental. So these are not people that are licensed. Is that correct? And I guess I'm directing this to Adam or to Bill.
Generally, yes, that would be correct.
Okay. So these could be considered just mom and pop folks that make a deal and they have a college student in, or there's a wedding that's occurring and they rent their house out for a week and it's just done, right? I mean, there's not a process per se that we as a city force them to submit an application or a permit or anything to, correct?
That's correct. So if someone wanted to rent out, let's say, an extra bedroom or a mother-in-law suite in their house,
right,
and they went through VBRO, Airbnb, Home to Go, et cetera, that process is not run through the city.
Okay. All right. So, I as I've learned being a part of this body, every law that we pass, there's people that cheer us and there's people that don't. And I guess I understand that. And I know there's a lot of questions
Outrage.
The outrage, the, you know, anger that the city could not do more. And I think that we need to pause, reflect, and hopefully get this thing done in 45 days. And I do feel bad for, you know, those folks that can't go through the Airbnb and all of the organized systems that are out there. But I think that in the long term, that it would help us to have current laws and ability to enforce the laws that we have. For right now, I think that that's all that I have. And again, I appreciate the fact that we need to dialogue about this. I am saddened that it erupted in such a terrible way on Saturday. I want to applaud the chief and our entire team and those who rendered assistance from other cities to control it. And as Chief said, there was no one hurt, and we can be happy about that, because during the short time that I was up there and around, tensions were extremely high. The stress was extremely high, and something could have gone really, really bad. And I want to congratulate those that responded to the call and did what they were able to do. And so I hope that we can have continued exchange. But at the end of the night, I hope that we can agree to pause, reflect, and get this done. So thank you, Mayor.
Thank you, Mendel. David?
Thank you, Mr. Mayor. While I find it exciting to realize that Glendora is becoming a destination city, it's kind of nice, but I think we need to help our businesses, our landlords, our current hotel and motel and innkeepers, to be fair to them and give them the opportunity for doing a legitimate business. And we need to make sure that our guests in these other situations value the reasons why they came to Glendora and why we choose to live here. It's sad that we're addressing these actions because of a few bad actors, and that does penalize for short term, I hope, the ones that are doing it correct. So I look forward to finding a solution with an ordinance correction or update, if you will, to address some of these questions. I do have a couple of questions, and anybody who can answer it is welcome. I'm not going to direct it to any one person, but we keep talking short-term rental and using the number 30 days. And I recognize that hotels and motels are regulated to stays of less than 30 days, I suppose, or else it becomes a long-term living opportunity and changes from hotel. But is there a legal definition of short-term rental, and is 30 days assigned to that?
I think the answer is no. There is a customary term in the industry. Why is 30 days significant? You stay longer than 30 days, you've created a landlord-tenant relationship. So you can't just kick somebody out after 30 days, especially if they keep paying rent. You got to go through the unlawful detainer procedure. So a short-term rental can be anything from 1 day to 29 days, as long as it's not more than 30, where you've converted that relationship from a licensee. Really, short-term rentals are in the law licensors and licensees, and licenses are revocable at will. As long as you don't get out of the licensor-licensee relationship into the landlord-tenant relationship, you can call a short-term rental almost any period of time you'd like.
Okay, because I was thinking a magic number like 38 might stop the guys from just hanging out for almost a month, but I understand the landlord-tenant relationship and I can respect that challenge. Not being a land baron, I don't know all those things, but as such, there are many homes in the city that are rentals and entrepreneurs. That's a good opportunity. Technically, are those entrepreneurs required to have a business license to do such?
So
I don't know.
if you rent a home, for example, yes, sort of long term, sort of the internet-based short-term rental industry, Councilman, is largely what we're talking about here, is sort of unregulated in Glendora.
Yeah, I understand that, but I'm just saying, my question is long-term rental, perhaps single family. So theoretically, I should have a business license to be a rentor. Okay, all right. So that may be something we should look at.
Absolutely.
In the short-term rental opportunities as well. Okay. One of the things, and there's been some great awarenesses brought to us this evening. Certainly the reasons people come to town, be it a family stay or a residential stay for a hospital visit or schooling, all legitimate reasons, and I respect those and certainly would hate to hamper those. If we are successful in blocking with the TRO, the temporary restraining order, is that just for short-term rental on this particular property, or is it for occupancy as well?
It applies only to this property and would prohibit renting this property out during the pendency of the temporary restraining order, the preliminary injunction, and if Ross prevails at trial, it would be a permanent ban. Our experience is once you get past the temporary restraining order, all of a sudden the defendant becomes very malleable and is willing to talk settlement. And we fully expect that if he's successful on Monday, we'll be able to sit down with this property owner and get this problem resolved on a long-term basis. But I'll let Ross weigh in on that as well.
Yeah, I think that's right. Getting over the initial hurdle of showing exactly what's going on at the property has a tendency to put the judicial officer in a position of trying to facilitate compliance. Most property owners do take the opportunity after that to negotiate, to try and come to terms, find compliance, a way to comply. And then, of course, we address any lingering issues associated with that as part of a stipulated judgment. That said, we're certainly prepared to go to summary judgment and trial. I've been doing this a while, and I think this is probably somewhere around 47 or 48 of these kinds of cases that I've had. So we're prepared to go either way. And certainly we welcome cooperation of the property owner and Mr. Bell. Barring that, we're prepared to go forward in the city's interest.
That's encouraging. Thank you. Through the administrative process, I understand there's a sum of fees that have been incurred on this, and I would hope that we might be able to be hardball on that and say this is the fee with some payment schedule as part of that settlement or discussion for the landlord. An absentee landlord, to Mr. Caddis's point, may not care, and it may be a moot point to them. But if we assign it to a lien on the property after a short period of time, not drag this out, that might help get their attention.
That's true. And what is unique is code enforcement in these kinds of cases is one of the very, very few circumstances in which the city is permitted to recover its costs and attorney's fees as a prevailing party. So not only would they have to pay these administrative fines at the end of the day as a part of any stipulated judgment, they're going to have to reimburse the city the cost that they've put us through to get to that point too.
Okay, yeah, we should not roll over easily on that, absolutely, because somehow they need to get their attention. In the
Well, let me just add, a judgment is only as valuable as the assets of the judgment debtor. We suspect our party promoter will be gone with the wind, but we'll do our best to get him and to make him pay.
Well, the landlord's still hanging out there, so I don't know if you have any recourse that way, but I certainly would encourage going that direction. In the interim ordinance that is proposed in sections, where'd we go here? Section C, section 4, item C, it talks about a $1,000 civil penalty pursuant to violating the ordinance. Is that per occurrence, per day, per? I mean, $1,000 is okay, but if it's hitting me every day that this goes on, that's an attention getter, perhaps.
So that, I'm glad you called that section to everybody's attention, council member. I know that one of the frustrations that you feel, and certainly the Burnsons feel, is why does this process take so flippin' long?
Yes.
And so we have built into this ordinance some summary proceedings that are as close to being able to walk in and summarily shut the place down as we can get under the law. And those are all articulated. That's why the remedies section of this ordinance is actually longer than the ordinance itself. So not only do you have the civil penalty, but because we are living in a state of emergency, we can use both the emergency powers of the municipal code and the emergency powers of the Code of Civil Procedure to engage in a summary abatement of a public nuisance, which will give law enforcement some more clout and will speed up the ability to enforce this prohibition in a more summary fashion. I think the one area where all of you have expressed to us the most frustration, not the least of which is the mayor, is why can't we walk in and shut these people down right now? Why can't we do that right now? And we've gone through and tried to explain as best we can the legal impediments to that, but the remedies section of the interim urgency ordinance is as close to being able to authorize the chief and his staff to go in and shut them down right now as we can get under the law. So it's not just the $1,000 penalty. That's probably an add-on feature. It's the provision that says you can use the declaration of a local emergency that exists both in the city and in the state, coupled with the health department orders, coupled with the municipal code, to engage in a summary abatement of a public nuisance. That is a pretty powerful tool. And that is a tool we will want to explore in crafting a more permanent short-term rental ordinance, if that's the wishes of the council. So subsection C, I'm glad, I apologize for not including that in my oral presentation, but I'm glad a member of the council raised that issue. So Councilmember Friedenhall, I would say the $1,000 penalty is not the real most powerful part of this remedies section.
Okay. And last point, as we craft this exploratory ordinance, let's keep in mind too, back in the old days of before houses became the destination, vacant commercial buildings were often used for such a event. So we might put into our awareness or into our vision the thought that those could be the go-to destination as we have real estate sitting around vacant buildings. It's a lot easier to use a big building, no restrooms, to cover that crowd, but let's keep those in mind as well. I hope we're able to, the legitimate folks are not penalized on this, and we can in fact take care of and respect our residents who have been misused for quite a while in this particular case. So, thank you for that.
Thank you, David. Gary? You with us, Gary?
Yeah, I'm there. Just unmute myself. You know, I'm sitting here, I've got 3 pages of questions and you know, we could go on and beat this thing to death, but the bottom line is we're talking about creating a moratorium tonight. And I could speak all evening on the attacks on the landlord business that people have been under by the state of California in the last number of years, but the last few months have been atrocious. And there's current legislation being considered to allow people to not pay rent until April of 2022. It may or may not be the same subject, but I can tell you for a fact there's people that got out of the long-term landlord business and into the short-term landlord business simply because we got a governor that tells people you don't have to pay your rent if you're a long-term tenant. This is a bigger issue than what we're addressing here tonight. And one of the things that's frustrating for me, and I owe an extreme apology to the Bertsons because I've known about this for a while. We should have addressed this before now. We've talked about it. We didn't take it serious enough. And I extremely apologize for the fact that I was not more adamant about getting some sort of solution with this. But what I am asking right now, what is going to be the difference if we have a moratorium in place and I rent my house out to Mendel and he decides to throw a wild party at my house? Are we going to be able to stop that party? Are we going to be able to go in and do anything on that Saturday night and actually make a difference? Or are we just going to end up fighting about this in court and possibly chasing somebody that doesn't have any money anyway? And this just becomes a circus. We know we need to resolve this, but I'm not sure the action we're considering taking tonight is going to do what we need to do. And if it's not, then we're punishing the legitimate people that are renting out these short-term rentals. And I agree we should have business licenses for them, but we don't even have that option for people. So no one can go in and get a business license in the city of Glendora tomorrow if they wanted to for a short-term rental. But I just need to hear somebody tell me what is the difference going to be if this party breaks out. Tomorrow's Friday. This party breaks out tomorrow night. We have a moratorium in place. What is the actual difference between what can be done tomorrow night? I don't want to hear what we can be done in court next Monday. I want to hear what can be done tomorrow night with a moratorium that can't be done if we don't have a moratorium in place. And
I think I can answer that question.
Okay, appreciate it.
If you would look at page 8 of your staff report, subsection C of the ordinance that Councilmember Friedendahl called everybody's attention to. I want you to read the sentence that refers to the civil penalty. Violations of this ordinance shall be punishable by a $1,000 civil penalty pursuant to Government Code 36901. Here's the next element that is the difference between the status quo and what this urgency ordinance could give you for the next 45 days. Violations of this ordinance may be abated on an emergency basis pursuant to Glendora Municipal Code 9.36.190, pursuant to California Code of Civil Procedures, section 3873773, or through any other remedy provided by law. So you've got a summary abatement procedure here. So if it were Friday night and there were to be a party Saturday night, we probably couldn't do anything until the party got started. But the moment the party got started, we think you could go in and summarily abate that party, especially if it's being rented through a short-term rental platform. So I think that gives you a little more oomph. But having said that, we are a nation of laws, and sometimes laws take a while to be enforced. And thank God that it does, because everybody gets to have their side of the argument aired. But this ordinance, in our judgment, would strengthen law enforcement's hands, at least for the next 45 days, with respect to party rentals, party ordinances and short-term rentals. And that's because we have declarations of national, state, and local emergencies in effect. We are living in the world of a pandemic. Whether you believe in the pandemic or not, county health officers do, and they've issued orders, and those orders are going to provide us additional enforcement options in our judgment.
Okay, so excuse me, Bill, because I'm a hillbilly from Ohio here. When you say that we have the ability to abate the situation, does that mean we can go in and put handcuffs on people and take them to jail if they refuse to leave the premises?
Yes.
Okay.
I mean, again, we're going to have to go in and say, this is a violation. This event is at an end. You are requested to leave. We're going to have to give people a reasonable period of time to comply with the law. But after one or more orders to disperse, you've seen it on television. Law enforcement will issue multiple orders to disperse. We'll give people every opportunity to voluntarily comply. But after some reasonable period of time, what's reasonable? Reasonable is in the eye of the beholder. Law enforcement will go in and make arrests.
But could we do that if there was no moratorium in place?
Not as clear. Maybe. Looks like the chief wants to weigh in on that.
Yeah, I was just gonna say that no one likes to hear this, but the word "it depends." So it depends on what's presented to us at the time, and in every occurrence where we're investigating something, a crime, a complaint, we have to weigh whether the force to correct the situation outweighs the risk and the liability, and if that force to correct that situation, meaning going in, putting handcuffs on somebody, will have the desired impact, whether it's worth it or not. Many times the goal, and you've heard this say before, but the goal of code enforcement, and at that point, police officers would be acting as code enforcement officers under the municipal code definition to abate this property. Our goal is always to do it in a fashion of three. First is to educate. So that is tell them what they're doing wrong and how to correct that behavior. Second is to allow time for compliance. And again, Bill proffered that eye of beholder for a reasonable amount of time. And that's different for every scenario. And then once compliance is not met, then enforcement can occur. And so at that point, we would weigh whether forcing our way into a property or onto a property or affecting an arrest is going to result in the desired outcome. And if we're faced with 3 or 4 people who are violating said order, or maybe 3 or 4 key individuals at a party who are particularly in defiance of that would be a good situation where we could effect a misdemeanor arrest. They'd be brought in, processed, issued a citation, and released. If we're faced with 300 or 400 people, that's a different story. We would choose to obviously have those 200 or 300 people leave in an efficient, safe manner so that we didn't have a violent encounter where we're overcome by several hundred people and need to bring in lots of other law enforcement resources. So we would probably direct our efforts towards a sponsor of the party or the main person involved.
And again, I appreciate the sensitive nature of having to make that call. And I trust that PD is always going to use the proper judgment to make those decisions. My question is there a difference between with a moratorium in place and without a moratorium in place, how that situation would be handled, or would it still be handled with making those judgment calls?
Well, it would still be made with those judgment calls. What Mr. Weiner was referring to is in the remedy section, it allows for us to enter that property and abate it. So that means normally when we approach a property or any kind of a private property incident, there's only 3 ways we can get onto that property, which is consent, warrant, or exigent circumstances. And barring those 3, we need something different. In this case, we would have an abatement issue by way of the remedy section, and that would allow us onto the property to abate it. So it would allow us access to the property, yes.
Having said that, you're right, Councilman Boyer. There's no magic bullet that is going to solve this problem.
No.
The purpose of the moratorium is not so much to enhance remedies, although because we have been sensitized to the concern of the neighbors and the concern of the council, we've spent our time trying to give you the maximum enforcement option. The purpose of a moratorium is to say, hey, folks, let's take a serious look at this problem, as Councilmember Thompson talked about, and let's stop what's going on right now until we can systematically study the issue and conclude how to best proceed. So that's its real purpose. And if in the consensus of the council, we're solving a single problem with a meat cleaver, I certainly get that. I get that. If, on the other hand, the council says, while this one problem is the straw that broke the camel's back, it has done at least forced us to focus on this problem and deal with it in a systematic and organized manner. And the way we can lawfully do that is through the use of moratoria. That's why we pay you the big bucks to make those calls.
Yeah. This is one of those situations that, again, we're put in a position that we have to take sides. And I have a real concern at the bigger picture here. It is not easy to be in the landlord business in California. And anything that we do to make that more difficult gives me grave concern as to what kind of effect that is going to have on the entire state. And I made a comment earlier that, one of the worst things that could happen for our housing crisis would be for us to put a moratorium in place, and it solves the problem right away. Because then other cities will look at that and go, well, we need to do the same thing. And before we know it, we have moratoriums throughout the entire state, and we lose more landlords, and we lose more rental properties available, and we have more people sleeping in their cars because they don't have a place to live. And you may think I'm being a little ridiculous here, but this is something that I deal with on a daily basis. And so that is my big concern as to whether or not this moratorium is taking a sledgehammer to kill the spider, but is it really going to kill the spider? If it's not, then I'm not sure the moratorium is the right answer. It's a false promise. I'm worried that it may be a false promise to our residents, and we're not going to have any more leverage than we do right now.
So, Councilmember Boyer, I think your concerns are absolutely legitimate. And my only one response is that short-term rentals are technically in the landlord business, but they're not your traditional landlord who rents out large properties over long-term and manages properties. These are onesie-twosies who are trying to make a little money on the side, which they may need to have to make in the pandemic world we are. But while they are certainly property managers, property owners, landlords in the strict legal sense of the word, they are not the typical property owners and property renters that you rightfully are concerned about. I don't know if that makes it any less angst for you or not, but.
No, and my argument with that, Bill, is that I can tell you right now that there are 3 landlords in Glendora who, when their properties became vacant, they took them off of the long-term rental rules and put them onto short-term rentals because long-term renters are not required to pay rent today. And we are in a situation that some of these people are trying any way possible to make enough money to pay their expenses, because when there's zero income coming in, there's still expenses going out. And as long as that is continuing, we're going to have more people trying to figure out ways to save their businesses. And these are businesses. Landlords are business people. And so it's part of a bigger picture. But that's where my concern is, and I'm just not hearing that a moratorium is really going to give us that much added teeth to stop this party when it begins. It gives us more tools after the fact, but I'm not sure that it's going to do anything, because the people that are doing this are lawbreakers, and us putting another law in place and a moratorium in place, I'm just not convinced that somebody is going to say, oh my goodness, there's a moratorium in place, I'm going to cancel the party where I'm going to make $25,000 tonight. So that's where my concern is. So, and again, this is a tough one.
Perfectly reasonable position.
That's really all I have. I'll save these questions for offline, but it's going to be a long discussion. And I'm glad this is finally happening. I, again, feel bad that it took Saturday night. Mendo, I jumped in my car and drove up there Saturday night as well. I saw PD there. I knew that they had things under control to the best of their ability, and I wasn't in the mood to party that night. So,
yeah.
But thanks to everybody.
Agreed.
This is a tough conversation.
And you were in your PJs, right? Thank you, Gary.
That was a private conversation, Michael, but yes, I actually was when I drove up there.
Well, we won't talk about those fire engine PJs. Karen?
Thank you. This whole situation, as mentioned before, brings up 3 issues: party houses, whether rentals or owner occupied, rentals that are unregulated, and the health order and the violation thereof. All very important issues. One of the questions that I have, and I think Mr. Caddis maybe alluded to this earlier, is does this moratorium affect if, for instance, somebody already has a reservation at a house, maybe they're having a wedding, maybe they're coming to visit their kid at APU and they choose to stay there instead of a hotel? Does this affect reservations that are already in place?
If a reservation is in place and the moratorium's adopted tonight, it would prohibit that event, yes.
Okay. As Gary said, in the middle of a pandemic, you hate to take away someone's ability to generate income. But at the same time, whether it's a rental house or owner occupied, the neighbors should not have to tolerate what has been occurring on Sierra Madre. So I think one thing that is not addressed by this, that hopefully maybe in the future, we can give the police department some other tools to just address party houses in general. So if there are other things that we could add to our GMC or other things that we could do to help them have a few more ways to penalize party houses, I think that would be good as well. But, if this moratorium gives us that chance to, take a breath and look at this whole industry and how we can regulate it to make it beneficial to neighborhoods, to residents, to the landlords themselves renting out, then, I think that might be the best way to go, as painful as that is, and not to put pressure on staff, but if you could do it quicker so that those people who are making an income off these rentals, that we can review this sooner so the people that are doing it correctly can get back to business. And meanwhile, we could look at how to get a handle on this a little bit better so that we don't have these party houses that people are using it the proper way. I know several folks who, when they travel, they prefer an Airbnb over a traditional motel or hotel. So the people that do it the right way, you don't want to penalize, but we can't continue to not address this area that is unregulated. So,
Mayor Pro Tem?
yes, sir.
I need to amend my answer. Lana reminds me that if there are people who have booked events that are occurring already, as long as no compensation has been exchanged, if you want to let your home be used for a wedding on one day, there's nothing in the moratorium that would prohibit that. If it's significant to you, we could modify the moratorium to say that it would take effect immediately, but would apply only to future bookings booked on and after the effective date of the moratorium. So that is an option we could explore as well.
Yeah, and I don't know how much that occurs, but I know that there have been instances in our city where if someone owns a large home or has a big piece of property, that there have been times when they've rented that out for a wedding. And just as much of an upheaval as people have had to deal with during the pandemic, I would hate to throw another curveball to somebody who's doing the right thing or planning a special event to say, oh, sorry, we're going to rain on your parade. But definitely we want to rain on the parade of the lawbreakers. So if there's any way to narrow that just a little bit so that we do go after the spider and not the cricket, that would be good.
Bill, I certainly would, support that. And I'm thankful that Lana spoke up because I agree with Karen. I mean, even at our church, there's been things planned and we've had to say no because the governor has changed, things around. And so if there's any way that some flexibility can be brought in, then I would certainly support that.
All right, council member, members of the council, take a look at page 7 of your staff report under section 4 moratorium, subsection B. For a period of 45 days after the date of August 27th, 2020, no new short-term vacation rentals or new short-term vacation rentals shall be permitted. So if you insert it after the comma following 2020 and before the word short-term new, I think that would take care of those circumstances that the Mayor Pro Tem was raising and that Councilmember Thompson was empathetic towards. What do you think about that, Lana?
I apologize, trying to unmute.
What if we insert the word new in subsection 4B after the date August 27, 2020, comma, new short-term vacation rentals shall be prohibited?
My only concern, and I might even tap in Ross on this answer as well, if he has any input, is that you have an existing short-term rental that is ongoing and has been a problematic site for the city.
So members of the council, this is why it's called practicing law.
Yeah. Could we get around that by saying that if it was something like that, like for instance, a wedding, with just family members, so it would still be in the health order, that they'd have to have a city permit So that way it's still regulated, or is that?
I think new gets it. I understand from Lana's perspective that might let a few people out, but to try to respond to Councilmember Boyer's concern that I'm using a meat cleaver to kill a spider, if we let a few of these glide under the radar during this 45-day period, I don't think that's the end of the world.
But how do we, Bill, how do we regulate that?
So if I can just jump in really quick, Mayor, in the proposed 45-day moratorium, it also indicates, as the city attorney sort of let out with, the fact is staff can't be everywhere all at the same time. The cost of personnel to preempt every single issue is too great. So this moratorium is enforced only if we receive a complaint about an issue that we would go out and investigate. So in a similar fashion, if this passed tonight and things went under the radar and we didn't know about it and there was no complaint, it would not be enforced because there was no issue. Similar to most things, if someone runs a stop sign and no one's there and no one sees it, we can't be everywhere all at the same time. And I think, you know, one or two that go in, if it's a huge wedding, there's supposed to be a special events permit anyway. So there are other ways in the enforcement that we would have to address it. And just to take a moment to address Councilman Boyer and Mayor Pro Tem Davis's concerns, is we acknowledge, and one of the things that we did learn is that from just a nuisance side with any home, I mean, it can be a relative inherits a house and decides to go nuts. We need additional tools for the police department to maybe even be more punitive in those areas, similar to the city of Los Angeles and their party house ordinance that they passed in 2018. And I believe that ordinance allows up to fines of $8,000 at the end. And so I think it's a number of fronts that we've learned. I don't think anyone, Bill or myself, want to bring forward an item that picks winners and losers. That's never the intention of staff. And I know that's not the intention of council. And so this moratorium would be enforced on a complaint basis, and with the small change that Bill has proposed, some of those events, if they would have been significant, would still occur. Additionally, issues that pop up would be handled by the police department and other parties with the utmost of professionalism to avoid any unnecessary use of force or any unnecessary interaction between the police department and guests of a party that's not supposed to happen. So it is a difficult conversation for sure. From a staff perspective, Bill's modifications wouldn't create too many issues.
But, you know, but can I just add, so going back to Bill, so with the abatement clause, and I'm sure I'm butchering your
right.
eloquent words, but with the abatement authority that we would have, then that would enable us, once we became aware of a complaint, then we would have the authority to go in and investigate. I mean,
Yes.
Is that correct?
Yes.
Okay.
Even if it landed after the fact, if we allowed it, then the abatement tool would not be able to be used.
Well, abatement by definition only works in advance or during. So if we learn about a problem afterwards, we have all of the other tools. We have administrative citations, and we always have the city prosecutor in our hip pocket.
Right, but if somebody has a reservation already and we go ahead and do this, that they are off the hook essentially, and the abatement tool will not be able to work.
That's true. If we create this exception, if somebody's paid good money already and over the Labor Day weekend are going to rent out their home for a short-term rental, and if that home turns into a 300-person party, we'll have to go back through what we went through this last time. No question about it.
Okay, with that in mind, and with Mr. Raymond's comments, I am happy leaving that addition out and keeping the moratorium the way that it is.
Okay.
Does that answer the question, Mendel?
Yes, and I'm glad I actually brought that up, and Bill was able to kind of clarify that, but I would support what Karen just said.
Karen, do you
Because we don't want to have that.
Karen, do you have any other questions or comments?
No.
Wonderful, thank you. Any final comments from the group?
I have one. Is there a way that we can stipulate, instead of exempting it to just new bookings, can we stipulate that any committed booking be reviewed by and permitted by the city prior to its occurrence?
Oh, man, now you're going to create a whole permitting process. I would advise against that. The thought is well-intentioned, but it would be an administrative challenge. I want to use the word nightmare, but challenge will do.
Understand.
But a great idea. Don't get me wrong. There are no bad ideas in solving this problem. But I think the council is coming to appreciate how naughty a problem this really is.
Yeah, and I think it's a good idea to get some resolution on this and a few of these other issues as well.
Any other questions?
Could I ask one other question?
Go ahead, Gary.
Would it be possible to create a moratorium on short-term rentals with an occupancy of 6 or more people?
Yeah, yes.
But yeah, Bill, actually, I considered that.
Why didn't we do that?
We could, but where do we draw the numbers? 6, 7?
Yeah, that's right. When does a short-term rental become a party house? More than 6, more than 10, more than 20? If you wanted to go by the county health officer orders, it would be more than 10, as I recall. Isn't that the current number now?
As long as they're all in the same family household.
Oh, that's right. Okay.
Well, and then
Never mind.
If this goes back to, and if Ross wants to jump in again, then I have to go back to the issue of how do you enforce the idea that this specific example started off as a rent
25.
rental that turned
25.
into a huge house party that that may be out of the control of the property owner.
If I can ask Councilman Boyer a clarification question, was your intention sort of on the advertised amount of people that would stay in that property? So all rentals moratoriums on advertising of more than X number of people?
Well, it could be on the advertising, but just on the idea that if there's a short-term rental, and we use the term vacation rental, and I will tell you that the majority of these short-term rentals are not vacation rentals, they're work rentals.
Right.
In a city like Glendora, in Malibu, I'm sure they're vacation, but here they're work rentals. And so, but if we had a situation where once there's over a certain number of people, then we could enforce the abatement issue. And again, I think
Sounds like something we ought to think about for 45 days.
That's right. I agree. Yeah, absolutely.
Not to be a smart aleck, but
but you are.
Well, Mr. Mayor, I'm ready to make the motion.
All right. First and foremost, I think that we have a duty to protect our citizens, and this is why we're here this evening. So with that, Madam Deputy City Clerk, can you read the draft motion, please?
At this time, the requested action is to adopt urgency ordinance 2454 entitled An Interim Urgency Ordinance of the City Council of the City of Glendora, California, approving a citywide 45-day moratorium prohibiting the advertising and operation of short-term rentals within the City of Glendora and declaring the urgency thereof, and to direct the city staff to study appropriate modifications to the city municipal code regulations to reduce and mitigate negative adverse secondary effects created by the number, location, and other impacts short-term vacation rentals may cause.
Thank you, Elviat. Do I have a motion?
I'll make that motion.
Do we have a second?
Second. Second.
And do we have a first and a second? Do we have any final comments or discussion? Hearing none, I'd like to take a poll vote. Mendel,
Aye or yes, support.
David,
Yes.
Karen,
Yes.
Gary. Unmute yourself. I can't read lips.
I trust the judgment of my colleagues, and I will reluctantly vote yes.
Thank you. And I will also vote in affirmative. Motion carries 5-0. So with that, I will adjourn our meeting at 7:24 p.m. Thank you, everyone.
Thank you, council.
Bye.
Good night.
Good night, everyone. Thank you.
Good night.